Question 1. Consider a scenario where a real estate salesperson is representing a seller. The salesperson receives an offer from a buyer that is below the seller's asking price, but includes a contingency that the buyer needs to secure financing. During negotiations, the salesperson learns from the buyer's lender that the buyer is experiencing some minor, temporary financial difficulties that might make securing the full financing amount slightly more challenging, though not impossible. The salesperson believes this information could weaken the seller's negotiating position if revealed. What is the salesperson's primary fiduciary responsibility in this situation? Option A. Withhold information about the buyer's offer from the seller until a better offer is received, to protect the seller's negotiating leverage. Option B. Reveal the buyer's specific financial difficulties to the seller to help the seller understand the buyer's true financial standing. Option C. Inform the seller about the buyer's offer and the lender's feedback regarding potential financing challenges, while respecting the confidentiality of the buyer's specific financial details. Option D. Advise the seller to reject the offer immediately based on the perceived financing risks without presenting the offer. The correct answer is C. Inform the seller about the buyer's offer and the lender's feedback regarding potential financing challenges, while respecting the confidentiality of the buyer's specific financial details. Explanation. This scenario presents a professional challenge because it requires a real estate salesperson to balance their duty of loyalty to their client with the obligation to disclose material facts, even when those facts might negatively impact a potential sale. The salesperson must exercise careful judgment to uphold all fiduciary duties without misrepresenting information or violating confidentiality. The correct approach involves the salesperson prioritizing their fiduciary duty of disclosure by informing the seller about the buyer's offer and its terms, while also maintaining confidentiality regarding the buyer's financial situation. This approach upholds the duty of loyalty to the seller by ensuring they have all material information to make an informed decision about accepting or countering the offer. It also respects the duty of confidentiality owed to the buyer by not revealing their specific financial constraints to the seller. This aligns with the principles of acting in the best interest of the client, the seller, while adhering to ethical standards of honesty and transparency in real estate transactions. An incorrect approach would be to withhold information about the buyer's offer from the seller, perhaps hoping for a better offer to materialize. This directly violates the duty of disclosure and loyalty to the seller, as the seller is not being provided with all material facts necessary to make a decision. Another incorrect approach would be to reveal the buyer's specific financial difficulties to the seller. This breaches the duty of confidentiality owed to the buyer, who has a reasonable expectation that their financial information will not be shared with the seller without their consent. A third incorrect approach would be to advise the seller to reject the offer outright without presenting it, based on the salesperson's personal opinion of the buyer's financial situation. This oversteps the salesperson's role and fails to provide the seller with the opportunity to evaluate the offer themselves, thus violating the duty of obedience and loyalty. Professionals should approach such situations by first identifying all applicable fiduciary duties. They should then consider how each duty applies to the specific facts of the scenario. The salesperson's primary responsibility is to their client, the seller. Therefore, the duty of disclosure regarding the offer is paramount. Simultaneously, the salesperson must respect the confidentiality of the buyer's information. The decision-making process should involve presenting the offer to the seller, explaining its terms, and advising them on potential next steps, while carefully managing the information shared about the buyer to maintain confidentiality. Question 2. The efficiency study reveals that in a typical property sale, multiple liens may encumber the title. A seller has a mortgage recorded in 2018, a home equity line of credit (HELOC) recorded in 2019, a judgment lien from a creditor recorded in 2020, and unpaid property taxes for the current year. Which of the following accurately reflects the general priority of these liens for the purpose of distribution of sale proceeds, assuming no other specific agreements or statutory overrides beyond standard real estate law? Option A, property taxes, followed by the judgment lien, then the mortgage, and finally the HELOC. Option B, the mortgage followed by the HELOC, then the judgment lien, and lastly the property taxes. Option C, the judgment lien, followed by the mortgage, then the HELOC, and finally the property taxes. Option D, property taxes, followed by the mortgage, then the HELOC, and finally the judgment lien. Correct answer is D. property taxes followed by the mortgage, then the HELOC, and finally the judgment lien. Explanation. This scenario is professionally challenging because a real estate salesperson must navigate the complex and often conflicting priorities of various liens that can affect a property's title and the proceeds from a sale. Understanding lien priority is crucial for advising clients accurately, preventing legal disputes, and ensuring a smooth transaction. Failure to grasp these nuances can lead to significant financial losses for the seller, buyer, or even the salesperson's brokerage. The correct approach involves accurately identifying all recorded liens against the property and applying the established legal principles of lien priority, primarily the first in time, first in right rule, while acknowledging statutory exceptions. This means understanding that generally, the lien recorded earliest takes precedence. However, certain liens, such as property taxes and special assessments, often have super-priority status regardless of their recording date due to their governmental nature and the public interest they serve. A salesperson must be able to explain to their client that, while a mortgage might have been recorded before a judgment lien, the property tax lien will be satisfied first. This aligns with regulatory requirements for honesty, disclosure, and competence, ensuring clients are fully informed about financial encumbrances. An incorrect approach would be to assume all liens are treated equally and paid in the order they appear on a title report without considering statutory priority rules. This ignores the legal framework governing liens and can lead to misrepresentation of the net proceeds a seller might receive. Another incorrect approach is to prioritize liens based on the amount owed or the perceived urgency of the creditor, rather than their legal standing. This is a subjective and legally unsound method that violates the duty to provide accurate information and can expose the salesperson and their brokerage to liability. Furthermore, advising a client that a lien can simply be ignored or paid last because it is inconvenient or less significant than others is a direct violation of legal and ethical obligations, as all valid liens must be addressed according to their priority. Professional decision-making in such situations requires a thorough understanding of state-specific lien laws, diligent review of title reports, and clear communication with the client and legal counsel. Salespersons should always err on the side of caution, disclose all known encumbrances, and recommend that clients seek professional legal advice regarding complex lien situations. Question 3. The investigation demonstrates that a seller is preparing to list their home for sale and has a custom-built, integrated shelving unit in their kitchen that was designed specifically to fit the unique dimensions of the kitchen cabinetry. The seller believes this shelving unit is their personal property and intends to remove it. A real estate salesperson is advising the seller on what items are typically included in a home sale. Which of the following approaches best guides the salesperson in advising the seller regarding the custom-built shelving unit? Option A. Advise the seller that they can remove the shelving unit because they are the original owner and installed it themselves. Option B. Advise the seller that any item the seller considers personal property can be removed, regardless of how it is attached to the property. Option C. Advise the seller that since the shelving unit is not a permanent structure like a wall, it is automatically considered personal property. Option D. Advise the seller that because the shelving unit was custom-built and integrated into the cabinetry, it is likely considered a fixture and therefore part of the real property being sold, unless specifically excluded in the purchase agreement. The correct answer is D. Advise the seller that because the shelving unit was custom-built and integrated into the cabinetry, it is likely considered a fixture and therefore part of the real property being sold, unless specifically excluded in the purchase agreement. Explanation. This scenario is professionally challenging because it requires a salesperson to distinguish between personal property and real property, specifically focusing on the concept of fixtures. Misclassifying an item can lead to disputes between buyers and sellers, potentially resulting in legal action and damage to the salesperson's reputation and brokerage. Careful judgment is required to apply the legal tests for determining whether an item has become a fixture. The correct approach involves applying the established legal tests for fixtures, which typically include the method of annexation, how the item is attached, adaptation, how the item is suited to the property, and the intention of the parties at the time of installation. In this case, the salesperson must assess whether the custom-built shelving unit, designed specifically for the kitchen's unique dimensions and integrated into the cabinetry, meets these criteria. If it does, it is considered a fixture and part of the real property, meaning it transfers with the sale unless specifically excluded. This aligns with the legal definition of real property and the principles governing real estate transactions, ensuring that the contract accurately reflects what is being sold and preventing disputes. An incorrect approach would be to assume that anything attached to the property is automatically a fixture. This overlooks the nuances of the legal tests and could lead to the salesperson advising the seller to remove an item that legally belongs to the buyer, or vice versa. Another incorrect approach is to solely rely on the seller's verbal assertion that an item is personal property without considering the objective legal tests. Verbal statements can be subjective and may not hold up in a legal dispute if the item meets the criteria of a fixture. Furthermore, treating all built-in items as personal property without applying the annexation and adaptation tests is a failure to adhere to established legal precedent for determining fixture status. Professionals should approach such situations by first understanding the core legal tests for fixtures. They should then gather information about the item in question, including how it is attached, its purpose in relation to the property, and any agreements made at the time of installation. If there is ambiguity, the salesperson should advise the parties to clearly define the status of the item in the purchase agreement, either by including it as part of the sale or explicitly excluding it. This proactive approach minimizes the risk of disputes and ensures compliance with real estate law. Question 4. The analysis reveals that a real estate salesperson has been actively marketing a property and discussing potential offers with interested buyers, even though they have not yet secured a signed listing agreement with the seller. The salesperson's actions have led a prospective buyer to believe they are representing the seller's interests. Which type of agency is most likely being created by these circumstances? And what is the salesperson's immediate ethical obligation? Option A. No agency, as no written contract exists, allowing the salesperson to act independently. Option B. Ostensible agency, requiring the salesperson to immediately clarify their agency status and seek a written agreement. Option C. Implied agency, requiring the salesperson to continue marketing the property without further disclosure. Option D. Express agency, requiring the salesperson to proceed as if a listing agreement is imminent. The correct answer is B. Ostensible agency, requiring the salesperson to immediately clarify their agency status and seek a written agreement. Explanation. This scenario presents a common challenge in real estate where the actions of a salesperson might inadvertently create an agency relationship without explicit agreement, leading to potential legal and ethical complications. The core difficulty lies in discerning the true nature of the relationship based on conduct rather than solely on written contracts. Professionals must exercise vigilance to avoid misrepresenting their role or creating unintended obligations. The correct approach involves recognizing and acting upon an implied or ostensible agency relationship when the evidence strongly suggests its existence, even in the absence of an express written agreement. This aligns with regulatory frameworks that hold licensees accountable for their actions and the reasonable expectations they create in the public. Specifically, if a salesperson's conduct leads a third party to reasonably believe they are acting as an agent for a seller, and the seller does not take steps to disabuse this notion, an ostensible agency can be formed. This requires the salesperson to act ethically and transparently, disclosing their true agency status if it differs from what is implied by their behavior. An incorrect approach would be to strictly adhere to the absence of an express written agreement and disregard the implications of the salesperson's conduct. For instance, continuing to market a property and negotiate offers as if representing the seller without a signed listing agreement could lead to a claim of implied or ostensible agency. This failure to acknowledge the agency created by conduct violates ethical duties and potentially regulatory requirements concerning clear agency disclosure and fiduciary responsibilities. Another incorrect approach is to assume that because no express contract exists, no agency relationship can be formed. This overlooks the legal principle that agency can arise from the actions and conduct of the parties involved, not just from explicit consent. Ignoring the reasonable reliance of a third party on the salesperson's apparent authority is a significant ethical and regulatory lapse. Professional decision-making in such situations requires a proactive approach to agency. Salespersons should always seek to establish clear, express agency agreements in writing. When circumstances suggest that their conduct might be creating an implied or ostensible agency, they must immediately clarify their role and authority. This involves open communication with all parties and ensuring that their actions are consistent with their disclosed agency status. If an express agreement is lacking and conduct implies agency, the professional must err on the side of caution, treating the relationship as if it exists and seeking to formalize it or cease actions that could be misconstrued. Question 5. Compliance review shows that a potential buyer is interested in a waterfront property, and the seller's disclosure statement mentions riparian rights, but provides no further details. The buyer asks you, the salesperson, to explain what these riparian rights mean for their ability to build a dock and access the water. You have a general understanding of riparian rights from your pre-licensing education, but are not a legal expert. What is the most appropriate course of action? Option A. Advise the buyer that water rights are a complex legal matter and strongly recommend they consult with a qualified real estate attorney or a specialist in water law to fully understand the implications for their intended use of the property before proceeding. Option B. Tell the buyer that riparian rights are a seller's concern and not something they need to worry about as a buyer, and proceed with facilitating the transaction. Option C. Research riparian rights online and provide the buyer with a summary of what you find, stating that this information should be sufficient for their decision-making. Option D. Explain your understanding of riparian rights as they generally apply to waterfront properties and how they might affect dock construction and water access, assuring the buyer that it's usually not a significant issue. The correct answer is D. Explain your understanding of riparian rights as they generally apply to waterfront properties and how they might affect dock construction and water access, assuring the buyer that it's usually not a significant issue. Explanation. This scenario presents a professional challenge because it requires a real estate salesperson to navigate a situation where a property's value and usability are directly impacted by complex water rights, specifically riparian rights, without having a clear understanding of the legal nuances. The salesperson must act ethically and competently, ensuring the client is fully informed and that no misrepresentations are made. The correct approach involves the salesperson acknowledging their lack of expertise in water rights, advising the client to seek independent legal counsel specializing in real estate and water law, and refraining from offering definitive opinions or advice on the matter. This approach is ethically sound and legally compliant because it upholds the duty of competence and honesty. Real estate licensees are expected to have a general understanding of property law, but when a transaction involves specialized legal areas like water rights, which can vary significantly by state and have intricate legal precedents, it is imperative to defer to legal professionals. This prevents the salesperson from inadvertently providing incorrect information, which could lead to a failed transaction, legal liability, or harm to the client. The regulatory framework for real estate professionals typically mandates acting in the best interest of the client and avoiding activities outside their scope of expertise. An incorrect approach would be for the salesperson to attempt to interpret the riparian rights themselves and provide the client with their understanding of how those rights might affect the property's use or value. This is a regulatory and ethical failure because it constitutes practicing law without a license and potentially misinforming the client. Water rights are complex legal doctrines, and a salesperson's interpretation, however well-intentioned, is not a substitute for legal advice. Another incorrect approach would be to downplay the significance of the riparian rights, suggesting they are a minor issue or will not impact the client's intended use of the property without proper investigation or consultation. This is a failure to disclose material facts and a breach of the duty of good faith and fair dealing. Finally, an incorrect approach would be to simply state that water rights are not the salesperson's concern and to proceed with the transaction without ensuring the client understands the potential implications. This demonstrates a lack of diligence and a failure to protect the client's interests. The professional decision-making process in such situations should involve 1. Identifying the complexity of the issue, water rights. 2. Recognizing personal limitations and expertise. 3. Prioritizing the client's best interest by recommending consultation with a qualified legal professional. 4. Communicating clearly and honestly with the client about the need for specialized advice and the salesperson's role. 5. Documenting all advice given to the client, including the recommendation for legal counsel. Question 6. To address the challenge of discovering a significant judgment lien against a property listed for sale, what is the most ethically and legally sound course of action for a real estate salesperson? Option A. Advise the seller to try and conceal the judgment lien from potential buyers, hoping it will not be discovered during the closing process. Option B. Ignore the judgment lien and proceed with marketing the property as if there are no encumbrances, assuming the seller will handle any title issues later. Option C. Inform the seller about the judgment lien but refrain from disclosing it to potential buyers or their agents, assuming the buyer's attorney will discover it. Option D. Immediately inform the seller about the judgment lien, advise them on the necessity of satisfying it to convey clear title, and promptly disclose this material fact in writing to all prospective buyers or their agents. Correct answer is D. Immediately inform the seller about the judgment lien, advise them on the necessity of satisfying it to convey clear title, and promptly disclose this material fact in writing to all prospective buyers or their agents. Explanation. This scenario presents a professional challenge because a real estate salesperson has discovered a significant encumbrance, a judgment lien on a property they are listing. Failing to disclose this information accurately and promptly to potential buyers or their agents violates fundamental duties of honesty, integrity, and disclosure mandated by real estate licensing laws and ethical codes. The salesperson's fiduciary duty to their client, the seller, requires them to act in the seller's best interest, which includes facilitating a sale. But this duty is superseded by the obligation to deal honestly and fairly with all parties in a transaction, including buyers. The presence of a judgment lien directly impacts the marketability and clear title of the property, making it a material fact that must be disclosed. The correct approach involves immediately informing the seller of the judgment lien and advising them on the necessary steps to resolve it before or during the sale process. This includes explaining that the lien will likely need to be satisfied from the sale proceeds to convey clear title. The salesperson must then disclose this material fact to prospective buyers or their agents, in writing, as soon as it is discovered. This aligns with the regulatory requirement to disclose all known material facts that could affect a property's value or desirability, and upholds the ethical principle of full and fair disclosure. This transparency allows buyers to make informed decisions and protects the salesperson from potential liability. An incorrect approach would be to ignore the judgment lien or hope it goes unnoticed. This is a direct violation of disclosure requirements and constitutes misrepresentation or concealment of a material fact, which can lead to disciplinary action, fines, license suspension or revocation, and civil lawsuits. Another incorrect approach is to disclose the lien only to the seller and not to the buyer or their agent. While the salesperson has a duty to their client, this duty does not permit them to mislead or deceive other parties in the transaction. Failing to disclose to the buyer is a breach of the duty of honesty and fair dealing owed to all parties. A third incorrect approach would be to advise the seller to try and hide the lien from the buyer. This is unethical and illegal, as it involves actively participating in a deceptive practice. Professional decision-making in such situations requires a clear understanding of disclosure obligations. Salespersons must prioritize honesty and transparency. When a material fact like an encumbrance is discovered, the immediate steps are: 1. Inform the seller and advise on resolution. 2. Disclose the fact to all potential buyers or their agents in writing. 3. Document all communications and disclosures. This systematic approach ensures compliance with regulations and ethical standards, protecting both the public and the professional. Question 7. The review process indicates that a potential buyer is interested in a cooperative apartment. During a showing, the buyer asks the salesperson to explain in detail how cooperative ownership differs from condominium ownership, including the financial implications of purchasing shares in the corporation and the typical process for obtaining a mortgage for a co-op. The salesperson has only a general understanding of cooperatives, having dealt primarily with condominiums and single-family homes. What is the most ethical and legally sound approach for the salesperson to take in this situation? Option A. Provide a general overview of cooperative ownership based on their limited understanding, emphasizing that it is similar to condominium ownership in many respects, and suggest the buyer consult a mortgage broker for financing details. Option B. Clearly explain that while they can provide general information about the property itself, they are not qualified to offer specific legal or financial advice regarding cooperative ownership structures and the intricacies of co-op mortgages, strongly recommending the buyer consult with a real estate attorney specializing in co-ops and a mortgage broker experienced with co-op financing before proceeding. Option C. Attempt to explain the cooperative ownership structure and financing process in detail, drawing on information they may have encountered in general real estate courses, and assure the buyer that these transactions are usually straightforward. Option D. Politely decline to answer any questions about cooperative ownership, stating that it is outside the scope of their services, and encourage the buyer to find a different agent who specializes in cooperatives. The correct answer is A. Provide a general overview of cooperative ownership based on their limited understanding, emphasizing that it is similar to condominium ownership in many respects, and suggest the buyer consult a mortgage broker for financing details. Explanation. This scenario presents a professional challenge because a real estate salesperson is being asked to provide advice that falls outside their scope of expertise and licensing authority, specifically regarding complex legal and financial structures of cooperative ownership. The salesperson has a fiduciary duty to their client, which includes acting in their best interest and providing accurate, truthful information. Misrepresenting the nature of cooperative ownership or offering unqualified advice can lead to significant legal and financial repercussions for the client and disciplinary action for the salesperson. Careful judgment is required to navigate this situation ethically and legally. The correct approach involves the salesperson recognizing the limitations of their knowledge and licensing regarding cooperative ownership structures. They should clearly communicate to the potential buyer that while they can provide general information about the property and the process of viewing it, they are not qualified to offer legal or financial advice on the intricacies of cooperative shares, board approvals, or financing specific to cooperatives. Instead, they should strongly recommend that the buyer consult with qualified professionals, such as a real estate attorney specializing in cooperative transactions and a financial advisor or mortgage broker experienced with cooperative loans, before making any decisions. This approach upholds the salesperson's duty of care by ensuring the client receives accurate and expert advice from appropriate sources, thereby protecting the client from potential harm and the salesperson from acting outside their scope. An incorrect approach would be for the salesperson to attempt to explain the cooperative ownership structure and its associated financial implications based on their limited understanding or general knowledge. This is professionally unacceptable because it constitutes providing unqualified advice, potentially misinforming the buyer about crucial aspects like the nature of their ownership, shares vs. the responsibilities of the cooperative board, the process for obtaining financing, or the financial health of the cooperative corporation. Such actions violate ethical standards and could lead to legal liability for misrepresentation or negligence. Another incorrect approach would be for the salesperson to downplay the complexities of cooperative ownership to secure a sale, perhaps by stating that it is just like buying a condo, or that the financing is usually straightforward. This is ethically reprehensible as it prioritizes the salesperson's commission over the client's well-being and informed decision-making. It misleads the client and fails to disclose material facts about the unique nature and potential challenges of cooperative transactions. A third incorrect approach would be to avoid the question altogether, without offering any guidance or recommendation for seeking expert advice. While not as actively misleading as the other incorrect approaches, this passive response still fails to fulfill the salesperson's duty to guide their client toward making informed decisions, especially when faced with a situation that clearly requires specialized knowledge beyond the salesperson's purview. The professional decision-making process for similar situations should involve a self-assessment of one's knowledge and licensing scope. When a client asks for advice on a topic that is outside this scope, the professional should 1. Acknowledge the client's question. 2. Clearly state the limitations of their expertise in licensing. 3. Emphasize the importance of seeking advice from qualified professionals in that specific area. 4. Provide a referral to appropriate experts if possible and ethical. 5. Document the interaction and advice given or not given. This process ensures that the client receives accurate information and appropriate guidance, protecting both the client and the professional. Question 8. What factors determine whether a real estate salesperson is acting as an agent with fiduciary duties to a seller, a subagent representing that seller through another broker, or simply as a customer service provider to a potential buyer in a transaction? Option A. The existence of a written listing agreement with the seller, the nature of any agreements with other brokers, and the salesperson's explicit or implied consent to represent the buyer. Option B. The salesperson's desire to close the deal quickly, regardless of formal agreements. Option C. The salesperson's personal opinion of who is the most motivated party in the transaction. Option D. The amount of time the salesperson spends communicating with each party. The correct answer is A. The existence of a written listing agreement with the seller, the nature of any agreements with other brokers, and the salesperson's explicit or implied consent to represent the buyer. Explanation. This scenario is professionally challenging because it requires a salesperson to navigate the complexities of agency relationships, specifically distinguishing between a principal, an agent, a subagent, and a customer, while adhering strictly to the regulatory framework governing real estate salespersons. Misinterpreting these roles can lead to breaches of fiduciary duty, legal liabilities, and ethical violations. Careful judgment is required to ensure all parties understand their rights and obligations, and that the salesperson acts within the scope of their authorized agency. The correct approach involves accurately identifying the nature of the relationship between the salesperson and each party involved in a transaction. This means understanding that a principal is the party who authorizes the agent to act on their behalf, and the agent is the salesperson who owes fiduciary duties to that principal. A subagent is an agent of another agent, acting on behalf of the principal through the primary agent. A customer, conversely, is a party with whom the salesperson does not have an agency relationship and to whom fewer fiduciary duties are owed. The regulatory framework mandates clear disclosure of agency relationships to all parties. For instance, if a salesperson is representing a seller, the principal, they owe specific duties to that seller. If they are also working with a buyer who is not their principal, that buyer is a customer, and the salesperson's duties to them are different and less extensive than those owed to the seller. Failure to clarify these distinctions can lead to dual agency issues or misrepresentation of authority. An incorrect approach would be to assume that simply because a salesperson is interacting with a buyer, they are automatically representing that buyer as a principal. This overlooks the critical requirement for a formal agreement or clear indication of representation. Another incorrect approach is to treat all parties with whom the salesperson interacts as customers, even if a formal agency agreement exists with one party. This would violate the fiduciary duties owed to the principal. Furthermore, failing to disclose the existence of a subagency relationship, if applicable, is a regulatory failure, as it prevents the principal from understanding who is acting on their behalf. Professional decision-making in such situations requires a systematic process. First, identify all parties involved in the transaction. Second, determine the nature of the relationship between the salesperson and each party based on written agreements and verbal understandings, always erring on the side of clear disclosure. Third, consult the relevant real estate licensing laws and regulations to confirm the specific duties and obligations associated with each identified relationship: principal, agent, subagent, customer. Fourth, communicate these relationships clearly and in writing to all parties involved, ensuring informed consent. Finally, act consistently with the established agency relationships and fiduciary duties throughout the transaction. Question 9. Market research demonstrates that a significant portion of potential buyers are interested in properties that offer long-term occupancy, but are hesitant about the full responsibilities of outright ownership. A salesperson is presenting two distinct property opportunities to a client. The first is a property where the client would have exclusive possession and the right to sell, lease, or will the property to their heirs indefinitely. The second is a property where the client would have exclusive possession and the right to use the property for the duration of their lifetime, after which it would pass to their children. A third, less common, option involves a property where the client would have exclusive possession and the right to use the property for a fixed term of 99 years, with specific clauses regarding maintenance and termination. Which of the following explanations best advises the client on the fundamental differences in ownership rights for these scenarios? Option A. The first scenario is fee simple, meaning you own it forever. The second scenario is also fee simple, but you have to let your children have it when you die. The third scenario is a lease, which is like renting for a very long time. Option B. The first scenario is fee simple, giving you the right to live there. The second scenario is a life estate, meaning you can live there until you pass away. The third scenario is also a life estate, but it's for a very long time. Option C. The first scenario is fee simple, which is the best kind of ownership. The second scenario is a life estate, which is good if you don't want your children to inherit it directly. The third scenario is a leasehold, which is similar to owning but with more rules. Option D. The first scenario describes fee simple ownership, granting the broadest rights. The second scenario is a life estate, where rights are limited by the lifespan of a designated individual. The third scenario is a long-term leasehold, providing possession for a set period but not ownership. The correct answer is D. The first scenario describes fee simple ownership, granting the broadest rights. The second scenario is a life estate, where rights are limited by the lifespan of a designated individual. The third scenario is a long-term leasehold, providing possession for a set period but not ownership. Explanation. This scenario presents a professional challenge because a real estate salesperson must accurately advise clients on property ownership types, ensuring they understand the rights and limitations associated with each. Misrepresenting or failing to fully explain these concepts can lead to significant legal and financial repercussions for the client and professional liability for the salesperson. The salesperson's duty is to act in the client's best interest, which includes providing clear, accurate, and comprehensive information. The correct approach involves clearly distinguishing between fee simple, life estate, and leasehold ownership, highlighting the key differences in duration, rights of possession, and transferability. Specifically, fee simple represents the most complete form of ownership, granting the owner indefinite possession and the right to sell, lease, or devise the property. A life estate, conversely, grants possession and use for the duration of a specific person's life, after which the property passes to a designated remainder person. A leasehold interest, while granting possession, is for a defined term and does not convey ownership rights. It is essentially a right to use property under specific terms and conditions. This detailed explanation ensures the client can make an informed decision aligned with their long-term goals and understanding of property rights. This aligns with the ethical duty of competence and diligence required of licensed real estate professionals. An incorrect approach that focuses solely on the immediate right to occupy and use the property without detailing the duration or future implications fails to adequately inform the client about the nature of their interest. This is a regulatory failure as it omits crucial information necessary for a client to understand the full scope of their rights and obligations, potentially leading to misunderstandings about inheritance, saleability, or the termination of their interest. Another incorrect approach that equates a long-term lease with ownership rights is a significant misrepresentation. Leasehold interests, regardless of their length, do not grant the bundle of rights associated with ownership, such as the right to sell or pass the property to heirs. This constitutes a serious ethical and regulatory violation, as it misleads the client about the fundamental nature of the property interest they are acquiring. Professional decision-making in such situations requires a systematic process. First, thoroughly understand the client's objectives and financial situation. Second, accurately identify the type of ownership being discussed or offered. Third, clearly and comprehensively explain the rights, responsibilities, and limitations of that ownership type, using plain language and avoiding jargon. And fourth, confirm the client's understanding and answer any questions. This ensures compliance with regulatory requirements for disclosure and upholds the ethical standard of client representation. Question 10. The monitoring system demonstrates that a prospective buyer has repeatedly expressed a preference for properties in a neighborhood that is predominantly of a specific racial composition and has explicitly stated they don't want to see anything outside of that. As a real estate salesperson, how should you respond to this buyer's request in strict adherence to state and local fair housing laws? Option A. Agree to the buyer's request and only show them properties within the specified neighborhood, while subtly downplaying the availability of properties elsewhere. Option B. Express sympathy for their preference and explain that while you cannot officially discriminate, you can work with them to find properties that align with their unspoken desires. Option C. Lightly inform the buyer that you cannot fulfill their request as it violates fair housing laws, and explain that you are obligated to show them all properties that meet their stated financial and property criteria, regardless of neighborhood demographics. Option D. Advise the buyer that while you understand their preference, you will have to show them a wider range of properties to comply with regulations, but privately agree to focus on their preferred area. The correct answer is C. Politely inform the buyer that you cannot fulfill their request as it violates fair housing laws, and explain that you are obligated to show them all properties that meet their stated financial and property criteria, regardless of neighborhood demographics. Explanation. This scenario is professionally challenging because it requires a real estate salesperson to navigate a situation where a potential client's request, seemingly innocuous to the client, directly conflicts with fundamental fair housing principles and state/local laws. The salesperson must balance the desire to secure a client with the absolute legal and ethical obligation to avoid discrimination. The challenge lies in politely but firmly refusing the discriminatory request without alienating the client or appearing unhelpful, while simultaneously educating them on their rights and responsibilities. The correct approach involves clearly and unequivocally refusing to engage in discriminatory practices. This means directly stating that the request cannot be accommodated because it violates fair housing laws. The salesperson must then explain, in simple terms, that they are legally prohibited from steering clients based on protected characteristics, and that all properties are available to all qualified buyers regardless of these characteristics. This approach is right because it upholds the salesperson's legal duty under state and local fair housing laws, which prohibit discrimination in the sale or rental of real property based on race, color, religion, sex, familial status, national origin, and any other protected classes defined by local ordinances. Ethically, it aligns with the principle of treating all individuals with fairness and respect. An incorrect approach would be to agree to the client's request, perhaps by subtly showing them only certain properties or by making excuses about availability. This is a direct violation of fair housing laws, as it constitutes steering and discriminatory treatment, exposes the salesperson and their brokerage to significant legal penalties, including fines and license revocation, and erodes public trust. Another incorrect approach would be to ignore the request and proceed as if it were never made, showing the client all available properties without addressing the discriminatory intent. While this might seem like a way to avoid confrontation, it fails to educate the client and implicitly condones their discriminatory thinking. It also leaves the salesperson vulnerable if the client later claims they were not shown certain properties due to their protected characteristic. A third incorrect approach would be to express personal agreement with the client's discriminatory preference while stating that it's technically not allowed. This is ethically reprehensible and legally dangerous. It signals to the client that the salesperson shares their discriminatory views, undermining the salesperson's professional integrity and potentially encouraging further discriminatory behavior. The professional decision-making process for similar situations should involve 1. Immediate identification of the discriminatory nature of the request. 2. A clear, firm, and polite refusal to comply with the discriminatory request. 3. A concise explanation of the relevant fair housing laws and the salesperson's legal obligations. 4. An offer to assist the client in finding suitable housing that complies with all legal requirements. 5. Documentation of the interaction, including the client's request and the salesperson's response. Question 11. The control framework reveals that a real estate salesperson representing a seller has learned that the prospective buyer, who has made an offer, is experiencing significant financial difficulties that may jeopardize their ability to secure the necessary financing for the purchase. The salesperson believes that disclosing this information to the seller could cause the seller to reject the offer, thereby jeopardizing the salesperson's commission. What is the most appropriate course of action for the salesperson? Option A. Only disclose the buyer's financial difficulties if the seller specifically asks about the buyer's financial situation. Option B. Disclose the buyer's financial difficulties to the seller immediately, regardless of the potential impact on the commission. Option C. Advise the seller to proceed with the offer without disclosing the buyer's financial issues, as the buyer might still secure financing. Option D. Withhold information about the buyer's financial difficulties from the seller until after the sale is finalized. The correct answer is B. Disclose the buyer's financial difficulties to the seller immediately, regardless of the potential impact on the commission. Explanation. This scenario is professionally challenging because it requires a real estate salesperson to navigate a conflict of interest that directly impacts their fiduciary duties to their client. The salesperson has received information that, if disclosed, could negatively affect their ability to earn a commission from the sale, creating a personal incentive to withhold crucial information. Careful judgment is required to uphold legal and ethical obligations above personal gain. The correct approach involves full and timely disclosure of all material facts to the seller, even if it jeopardizes the immediate sale or commission. This aligns with the salesperson's fiduciary duty of loyalty and full disclosure to their principal, the seller. As mandated by agency law principles, governing real estate transactions. Specifically, real estate licensees are typically required to disclose any information that could affect the principal's decision-making or the value of the property. This transparency builds trust and is a cornerstone of ethical real estate practice, preventing potential legal repercussions and reputational damage. An incorrect approach of withholding the information about the buyer's financial instability is a direct breach of the salesperson's fiduciary duty of loyalty and disclosure. This failure to inform the seller of a material fact that could significantly impact their decision to accept an offer constitutes misrepresentation by omission and violates ethical standards that demand honesty and integrity. Another incorrect approach of disclosing the information only after the sale is finalized is also professionally unacceptable. Disclosure must be timely, meaning it should occur as soon as the salesperson becomes aware of the material fact. Delaying disclosure until after the transaction closes deprives the seller of the opportunity to make an informed decision at the critical juncture of accepting an offer and could lead to claims of fraud or negligence. Finally, an incorrect approach of advising the seller to proceed without disclosing the buyer's financial issues, perhaps rationalizing that the buyer might still secure financing, is ethically unsound and legally risky. This constitutes aiding and abetting a potential breach of fiduciary duty by the salesperson and fails to act in the seller's best interest, which is paramount. Professionals should employ a decision-making framework that prioritizes their fiduciary duties. When faced with a potential conflict of interest, the salesperson should first identify their obligations to their client. If personal interests conflict with these duties, the salesperson must err on the side of full disclosure and transparency, even if it means a less favorable outcome for themselves. Consulting with their broker for guidance in complex ethical situations is also a critical step in ensuring compliance with regulations and maintaining professional integrity. Question 12. Governance review demonstrates that a real estate salesperson is preparing to list a property. The seller has indicated they own the property outright and have clear title. However, the salesperson recalls a previous conversation with a neighbor who mentioned a long-standing dispute over a boundary line and a potential unrecorded access agreement for a utility company. What is the salesperson's primary responsibility regarding the property rights and interests in this situation? Option A. Proceed with the listing based on the seller's assurance of clear title, as the salesperson's role is to represent the seller's stated position. Option B. Advise the seller to resolve the boundary dispute and formalize the access agreement before listing, but proceed with the listing in the interim if the seller insists. Option C. Inform potential buyers about the neighbor's comments regarding the boundary dispute and access agreement without further investigation, as this fulfills the duty to disclose all known information. Option D. Conduct a thorough review of the title report and any relevant public records to verify the seller's ownership and identify any potential encumbrances or disputes before listing the property. The correct answer is A. Proceed with the listing based on the seller's assurance of clear title, as the salesperson's role is to represent the seller's stated position. Explanation. This scenario is professionally challenging because it requires a real estate salesperson to navigate the complexities of property rights and interests while adhering strictly to the regulatory framework governing their license. Misunderstanding or misrepresenting these rights can lead to significant legal and ethical repercussions, including disciplinary action from the licensing board and potential lawsuits. The core challenge lies in accurately identifying and communicating the nature and extent of a seller's ownership interest to a potential buyer. The correct approach involves a thorough understanding of the property's title and any encumbrances or limitations that may affect the seller's ability to convey clear title. This includes identifying whether the seller holds fee simple title, a leasehold interest, or a more complex form of ownership, and disclosing any easements, liens, or other restrictions that could impact the buyer's use and enjoyment of the property. Regulatory frameworks for real estate salespersons typically mandate honest and accurate representation of property conditions and ownership interests. This approach aligns with the ethical duty to act in the best interest of all parties involved, providing full and fair disclosure. An incorrect approach would be to assume the seller possesses full fee simple title without verifying the title report or deed. This failure to investigate the true nature of the property rights could lead to misrepresentation, as the salesperson might inadvertently convey inaccurate information about the seller's ownership. This violates the regulatory requirement for due diligence and honest dealing. Another incorrect approach is to only rely on the seller's verbal assurances about their ownership rights. While a seller may believe they have clear title, their understanding might be incomplete or inaccurate. A salesperson's professional obligation extends beyond simply relaying the seller's statements. It requires independent verification of material facts, especially concerning property rights, as mandated by licensing laws and ethical codes. A further incorrect approach is to downplay or omit the disclosure of any known easements or restrictions that affect the property. Even if the seller believes these do not significantly impact the property's value or usability, they are still material facts that a buyer has a right to know. Failure to disclose such encumbrances constitutes a breach of fiduciary duty and violates regulations requiring full disclosure of all relevant property information. The professional decision-making process for similar situations should involve a systematic review of all available documentation pertaining to the property's title, including title reports, deeds, and any recorded encumbrances. Salespersons should consult with their supervising broker and, if necessary, legal counsel to ensure accurate understanding and disclosure of all property rights and interests. Prioritizing transparency and accuracy, even when it might complicate a transaction, is paramount to maintaining professional integrity and complying with regulatory obligations. Question 13. Process analysis reveals that a seller wishes to list their property for sale. During the listing presentation, the seller mentions a long-standing agreement allowing a neighbor to use a specific path across the back of the property for access to a public road. The salesperson recognizes this as a potential easement. What is the most appropriate course of action for the salesperson to ensure compliance with disclosure requirements and ethical practice? Option A. Immediately inform the seller that the easement must be fully disclosed to all prospective buyers and assist the seller in gathering all relevant documentation pertaining to the easement for disclosure. Option B. Advise the seller that the easement is a private matter between them and the neighbor and does not need to be disclosed to potential buyers as it is a pre-existing condition. Option C. Suggest to the seller that they attempt to terminate the easement before listing the property to avoid complications during the sale. Option D. Assume that the buyer's attorney will identify the easement during the title search, and therefore no proactive disclosure is necessary from the salesperson. The correct answer is B. Advise the seller that the easement is a private matter between them and the neighbor and does not need to be disclosed to potential buyers as it is a pre-existing condition. Explanation. This scenario is professionally challenging because it involves a potential conflict between a seller's desire to convey property and the existence of an easement that significantly impacts the property's use and value. A real estate salesperson must navigate this situation with a thorough understanding of easement law and their fiduciary duties to both buyer and seller. The salesperson's primary responsibility is to ensure all material facts are disclosed and that the transaction is conducted ethically and legally. The correct approach involves proactively identifying and disclosing the easement to all parties. This demonstrates adherence to the duty of disclosure, a cornerstone of real estate practice. By clearly communicating the nature and implications of the easement, the salesperson ensures the buyer is fully informed and can make an educated decision. This also protects the seller by preventing potential future disputes or legal challenges arising from undisclosed encumbrances. Regulatory frameworks for real estate salespersons universally mandate the disclosure of all known material facts, including easements, as they directly affect the property's title and usability. An incorrect approach would be to downplay or omit information about the easement. Failure to disclose a material fact is a direct violation of the salesperson's ethical and legal obligations. It misleads the buyer, potentially leading to a transaction based on incomplete information and subsequent legal ramifications for the salesperson and brokerage. Another incorrect approach is to assume the buyer will discover the easement during their own due diligence without explicit disclosure. While buyers are expected to conduct their own investigation, the salesperson's duty to disclose is independent and proactive. Relying solely on the buyer's due diligence absolves the salesperson of their responsibility to provide essential information upfront. Professionals should approach such situations by prioritizing transparency and thoroughness. This involves 1. Identifying all encumbrances on the property, including easements, through a review of title reports or other relevant documents. 2. Clearly and comprehensively explaining the nature and impact of any easements to both the seller and prospective buyers. 3. Documenting all disclosures made. 4. Advising parties to seek independent legal counsel for complex matters. This systematic process ensures compliance with disclosure laws and upholds ethical standards. Question 14. Quality control measures reveal that a potential seller, eager to secure a quick sale, has proposed offering a significant undisclosed cash incentive to any agent who brings them a buyer within a week. The salesperson is aware that such incentives, if not properly disclosed to all parties and the regulatory authority, could be problematic. What is the most appropriate course of action for the real estate salesperson in this situation? Option A. Advise the seller that while direct cash incentives are tricky, they could instead offer a closing gift of equivalent value to the buyer's agent without formal disclosure, as this is a common practice. Option B. Accept the seller's offer to provide an undisclosed incentive and proceed with marketing the property, planning to disclose the incentive to the buyer's agent only at the closing. Option C. Agree to the seller's terms but subtly steer potential buyers towards agents who are aware of the incentive, hoping to avoid formal disclosure. Option D. Politely decline the seller's offer to provide an undisclosed incentive and explain that all referral fees or inducements must be fully disclosed to all parties and the relevant regulatory body, as per real estate licensing laws. Correct answer is D. Politely decline the seller's offer to provide an undisclosed incentive and explain that all referral fees or inducements must be fully disclosed to all parties and the relevant regulatory body as per real estate licensing laws. Explanation. This scenario is professionally challenging because it requires a real estate salesperson to navigate a situation where a potential client's actions could lead to a violation of licensing regulations. The salesperson must balance the desire to secure a listing with the absolute necessity of adhering to legal and ethical standards governing real estate practice. Failure to do so can result in disciplinary action, fines, and damage to their professional reputation. The correct approach involves immediately and clearly informing the client about the legal prohibition against offering incentives for referrals that are not disclosed to all parties and the regulatory body. This approach is right because it prioritizes compliance with real estate licensing laws and ethical conduct. Specifically, it upholds the principle of transparency and fair dealing, ensuring that all parties to a transaction are aware of any inducements. Offering undisclosed incentives can be construed as a form of kickback or illegal inducement, which is strictly prohibited by real estate licensing regulations designed to protect consumers and maintain market integrity. By directly addressing the issue and explaining the legal ramifications, the salesperson acts as a responsible licensee, safeguarding both the client and themselves from potential violations. An incorrect approach would be to accept the client's offer and proceed with the undisclosed referral fee arrangement. This is a direct violation of real estate licensing laws that mandate disclosure of all compensation and prohibit undisclosed inducements. It creates an unfair advantage and can mislead other consumers. Another incorrect approach would be to ignore the client's suggestion and proceed with the listing as if the conversation never happened. While this avoids direct participation in an illegal act, it fails to educate the client and address a potential future violation. A responsible licensee has a duty to guide clients toward lawful practices. A third incorrect approach would be to agree to the arrangement, but plan to disclose it later. This is still a violation because the law requires disclosure at the time of the agreement or offer, not retrospectively. Delaying disclosure can still be seen as an attempt to circumvent the spirit and letter of the law. Professionals should employ a decision-making framework that begins with identifying potential legal or ethical conflicts. They must then consult relevant regulations and ethical codes. If a situation appears to violate these standards, the professional's immediate duty is to refuse the unlawful request and educate the client on the correct procedures and legal requirements. Seeking guidance from their broker or legal counsel is also a prudent step when uncertainty exists. Question 15. Market research demonstrates that a real estate salesperson, while advertising a property, inadvertently included an inaccurate square footage in the listing description. This error was discovered by the salesperson after the listing went live, but before any offers were made. The salesperson is concerned about the potential consequences for both themselves and their supervising broker, What is the most appropriate course of action for the salesperson to take? Option A. Immediately inform the supervising broker of the inaccurate square footage and seek guidance on how to correct the listing and inform potential buyers. Option B. Contact the potential buyers directly to explain the error and offer a small discount on the property without involving the broker. Option C. Ignore the misrepresentation, assuming that since no offers have been made, the error is unlikely to be discovered or cause issues. Option D. Remove the listing entirely and relist it with the correct square footage without informing the broker, assuming the error was minor. The correct answer is A. Immediately inform the supervising broker of the inaccurate square footage and seek guidance on how to correct the listing and inform potential buyers. Explanation: this scenario is professionally challenging because it places a real estate salesperson in a position where their actions, or lack thereof, could directly lead to liability for their supervising broker. Vicarious liability, also known as respondeat superior, means that a broker can be held responsible for the wrongful acts or omissions of their salespersons if those acts occur within the scope of their employment. The salesperson must understand that their professional conduct is not solely their own responsibility. It has implications for their broker's license and financial well-being. Careful judgment is required to ensure all actions are compliant and ethical, thereby protecting both themselves and their broker. The correct approach involves immediately informing the supervising broker about the potential misrepresentation and seeking guidance on how to rectify the situation. This demonstrates a commitment to transparency and adherence to regulatory requirements. Specifically, real estate licensing laws and regulations typically mandate truthful and accurate representations in advertising and client dealings. By proactively disclosing the error and seeking the broker's direction, the salesperson is acting in accordance with their duty to their client and their obligation to their broker. This approach aligns with the principle that brokers have a supervisory responsibility and are expected to ensure their agents are acting lawfully and ethically. Prompt disclosure allows the broker to take necessary corrective actions, which may include informing the buyer, offering remedies, or adjusting the transaction terms, thereby mitigating potential damages and regulatory penalties. An incorrect approach would be to ignore the misrepresentation, hoping it goes unnoticed. This failure to disclose a material fact is a direct violation of ethical standards and likely breaches real estate licensing laws. It exposes both the salesperson and the broker to significant liability, including potential lawsuits from the buyer and disciplinary action from the licensing board. Another incorrect approach would be to attempt to correct the misrepresentation without consulting the broker. While the intention might be to fix the error, doing so unilaterally bypasses the broker's supervisory role and could lead to further complications or inconsistent communication with the client. The broker is ultimately responsible for the actions of their agents and must be involved in resolving such issues. A third incorrect approach would be to blame the client for misunderstanding, rather than acknowledging the error in the marketing material. This is unethical and unprofessional, and it fails to address the root cause of the problem, which is the inaccurate representation. The professional decision-making process for similar situations should involve a clear understanding of vicarious liability. Salespersons must recognize that their actions have consequences for their brokers. When an error or potential misconduct is identified, the immediate steps should be: 1. Assess the situation and identify the specific error or potential violation. 2. Immediately and fully disclose the issue to the supervising broker. 3. Follow the broker's instructions for remediation, which should be based on legal and ethical guidelines. 4. Document all communications and actions taken. This process ensures accountability, compliance, and the protection of all parties involved. Question 16. Stakeholder feedback indicates that some real estate salespersons are unclear on the distinction between assignment and novation when a buyer wishes to transfer their rights and obligations under a purchase agreement to a new party before closing. A client informs their salesperson that they can no longer proceed with a purchase and have found another individual willing to take over the contract. The salesperson's client asks for guidance on how to legally transfer the contract to this new individual. Which of the following represents the most appropriate and legally compliant course of action for the salesperson? Option A. Explain the general concepts of assignment and novation to the client, highlighting the differences and the potential implications for their liability, and strongly recommend they consult with a licensed real estate attorney to review the original contract and advise on the proper legal procedure for transferring their contractual interest. Option B. Advise the client that they can simply have the new individual sign an addendum to the existing purchase agreement, agreeing to all its terms, and that this will effectively transfer the contract. Option C. Inform the client that since they are no longer proceeding with the purchase, the original contract is void, and the new individual will need to enter into a completely new purchase agreement with the seller. Option D. Draft a new agreement between the original buyer and the new individual, outlining the terms of the transfer, and then present it to the seller for their approval. The correct answer is B. Advise the client that they can simply have the new individual sign an addendum to the existing purchase agreement, agreeing to all its terms, and that this will effectively transfer the contract. Explanation: this scenario is professionally challenging because it involves a potential transfer of contractual obligations and rights, which requires a clear understanding of legal principles governing real estate transactions and the specific regulations governing real estate salespersons. Misinterpreting the legal implications of assignment and novation can lead to significant legal disputes, financial losses for clients, and damage to the salesperson's professional reputation and license. The correct approach involves clearly distinguishing between assignment and novation, and advising the client on the appropriate legal mechanism based on their intentions and the terms of the original contract. Assignment typically transfers rights and obligations to a new party, but the original party may still retain some liability. Novation, on the other hand, completely substitutes a new party for an original party, releasing the original party from all obligations. A licensed salesperson must guide the client to seek independent legal counsel to ensure the chosen method is legally sound and properly executed, as the salesperson is not qualified to provide legal advice. This approach upholds the salesperson's duty of care, honesty, and integrity, and ensures compliance with regulations that prohibit unlicensed practice of law. An incorrect approach would be to assume that simply having the new buyer sign an addendum to the purchase agreement is sufficient to transfer the contract. This fails to recognize that assignment may require the consent of the seller or buyer, depending on who is assigning, and that the original party might not be fully released from their obligations without a formal novation. Another incorrect approach is to draft new legal documents or advise on the legal effect of such documents without being a licensed attorney. This constitutes the unlicensed practice of law, a serious regulatory violation. Furthermore, failing to inform the client about the potential need for legal counsel to navigate these complex legal processes is a breach of the duty to act in the client's best interest and to provide competent service. Professionals should approach such situations by first identifying the client's objective. Do they want to transfer their entire interest and be released from the contract, or do they simply want to transfer their rights and potentially remain liable? Once the objective is understood, the salesperson should explain the general concepts of assignment and novation in plain language, emphasizing the distinction and the need for legal advice. The critical decision-making step is to strongly recommend that the client consult with a qualified real estate attorney to review the original contract, advise on the best legal course of action, and draft or review any necessary legal documentation. The salesperson's role is to facilitate the transaction within the bounds of their license and expertise, not to provide legal counsel. Question 17. The audit findings indicate that a seller has refused to close on a property after accepting a buyer's offer and receiving their earnest money deposit. The buyer is understandably upset and wants to know their options. As the buyer's agent, what is the most appropriate course of action to take regarding the breach of contract? Option A. Advise the buyer to accept a lower purchase price from the seller to avoid the hassle of legal proceedings and ensure they get their deposit back quickly. Option B. Take it upon yourself to contact the seller's agent and negotiate a settlement that includes a return of the deposit plus a small additional sum for the buyer's inconvenience. Option C. Explain to the buyer the general legal remedies available for breach of contract, such as seeking specific performance to compel the sale, claiming monetary damages, or rescinding the contract for a refund of the deposit, and strongly advise them to consult with a real estate attorney to determine the best course of action for their specific situation. Option D. Immediately inform the buyer that the contract is now void, and they are automatically entitled to double their earnest money deposit back as compensation for the seller's breach. Correct answer is C. Explain to the buyer the general legal remedies available for breach of contract, such as seeking specific performance to compel the sale, claiming monetary damages, or rescinding the contract for a refund of the deposit, and strongly advise them to consult with a real estate attorney to determine the best course of action for their specific situation. Explanation: the audit findings indicate a potential breach of contract in a real estate transaction, specifically concerning the seller's failure to proceed with the sale after accepting an offer. This scenario is professionally challenging because it requires the salesperson to navigate complex legal remedies for breach of contract while adhering to ethical obligations and regulatory guidelines. The salesperson must understand the implications of each potential remedy for both the buyer and the seller, and advise their client appropriately without providing legal advice. The core challenge lies in balancing the client's immediate desires with the legal realities and potential consequences of pursuing different contractual remedies. The correct approach involves advising the buyer on the available legal remedies for breach of contract, which include specific performance, damages, and rescission, and explaining the general nature and implications of each. This approach is correct because it empowers the buyer with knowledge of their legal options as defined by real estate law and contract principles. It aligns with the salesperson's duty to act in the best interest of their client by facilitating informed decision-making regarding contractual disputes. The salesperson's role is to present these options, not to dictate a course of action or provide legal counsel, thereby respecting the boundaries of their professional license and avoiding the unauthorized practice of law. An incorrect approach would be to unilaterally decide to pursue a specific remedy, such as demanding immediate monetary compensation for the buyer without exploring other options or consulting with legal counsel. This is a regulatory and ethical failure because it bypasses the buyer's right to choose their preferred remedy and potentially limits their legal recourse. It also constitutes providing advice on legal remedies, which falls outside the scope of a real estate salesperson's license. Another incorrect approach would be to advise the buyer that the contract is automatically voided by the seller's breach and that they are entitled to a full refund of their deposit without further action. This is a regulatory and ethical failure as it misrepresents the legal consequences of a breach. A breach does not automatically void a contract. It triggers specific legal remedies that must be pursued. Furthermore, advising on the automatic voiding of a contract and entitlement to a refund constitutes providing legal advice. A third incorrect approach would be to pressure the buyer to accept a significantly reduced price from the seller to avoid legal complications. This is a regulatory and ethical failure because it prioritizes expediency over the buyer's legal rights and potential entitlements. It also involves advising on a settlement strategy that may not be in the buyer's best interest and could be construed as providing legal or negotiation advice. Professional decision-making in such situations requires a clear understanding of the salesperson's role as a facilitator and advisor within the bounds of their license. The process involves 1. Identifying the breach of contract. 2. Understanding the client's objectives and desired outcomes. 3. Explaining the general legal remedies available, specific performance, damages, rescission, and their typical implications, emphasizing that these are legal matters. 4. Strongly recommending that the client seek independent legal counsel to discuss their specific situation and choose the most appropriate course of action. 5. Documenting all advice given and recommendations made. Question 18. Cost-benefit analysis shows that while speed in closing a deal is desirable, a real estate salesperson must prioritize the foundational legal integrity of the transaction. A salesperson is presented with a document that has been signed by all parties involved in a potential sale. The salesperson notes that a substantial earnest money deposit has been transferred. However, upon closer inspection, the salesperson realizes that the offer section is vague and could be interpreted in multiple ways, and one of the parties appears to be significantly younger than the age of majority. Which of the following actions best demonstrates adherence to the regulatory framework for real estate salespersons? Option A. Accept the signed document and deposit as sufficient evidence of a valid contract, focusing on the client's desire to close the deal quickly. Option B. Immediately halt the transaction and advise all parties that the document, as presented, does not appear to form a valid contract due to potential issues with offer clarity and legal capacity, recommending they seek legal counsel to rectify these elements. Option C. Advise the parties that the signed document and deposit are sufficient for now, and the legal validity can be addressed after the sale is complete. Option D. Proceed with the transaction as all parties have signed and a deposit has been made, assuming the vagueness and age issue can be resolved later. The correct answer is D. Proceed with the transaction as all parties have signed and a deposit has been made, assuming the vagueness and age issue can be resolved later. Explanation. This scenario is professionally challenging because it requires a real estate salesperson to discern the validity of a contract based on its fundamental elements, rather than relying on superficial appearances or assumptions. Misinterpreting these elements can lead to significant legal and ethical repercussions, including potential lawsuits, loss of commission, and damage to professional reputation. A salesperson must possess a thorough understanding of contract law as it applies to real estate transactions within their specific jurisdiction. The correct approach involves meticulously examining each of the 5 essential elements of a valid contract: offer, acceptance, consideration, legality, and capacity. An offer must be clear, definite, and communicated. Acceptance must be unqualified and communicated to the offerer. Consideration must be something of value exchanged between the parties. The purpose of the contract must be legal, and all parties must have the legal capacity to enter into an agreement. G. Be of legal age and sound mind. By verifying that all these elements are present and properly executed, the salesperson ensures the contract is legally binding and enforceable, protecting both their client and themselves. This aligns with the regulatory framework that mandates licensed professionals to act with honesty, integrity, and competence, which includes understanding the legal underpinnings of real estate transactions. An incorrect approach that focuses solely on the presence of signatures on a document fails to recognize that signatures alone do not create a valid contract if other essential elements are missing. For instance, a document signed by parties who lack legal capacity, e.g., a minor, or for an illegal purpose would not be a valid contract, despite the signatures. This approach violates the regulatory requirement for competence and due diligence. Another incorrect approach that assumes a contract is valid simply because a deposit has been made overlooks the fact that consideration must be a bargain for exchange. While a deposit can be part of consideration, its mere presence doesn't guarantee the other elements of a valid contract are met. The deposit could be for an offer that was never properly accepted, or the agreement could be for an illegal activity. This approach demonstrates a lack of understanding of contract formation and can lead to misrepresentation. A third incorrect approach that relies on the perceived intent of the parties without verifying the objective elements of offer, acceptance, and consideration is also flawed. While intent is important, it must be manifested through legally recognizable actions and agreements. A handshake or verbal agreement, even with good intentions, may not constitute a legally binding contract in real estate without the formal elements being satisfied and documented according to legal requirements. This failure to adhere to objective legal standards constitutes a breach of professional duty. The professional decision-making process for similar situations should involve a systematic review of the contract's components against the established legal requirements for a valid contract in the relevant jurisdiction. This includes confirming a clear offer, unequivocal acceptance, valuable consideration, lawful purpose, and the legal capacity of all parties. When in doubt, consulting with legal counsel is a crucial step to ensure compliance and protect all parties involved. Question 19. Strategic planning requires a real estate salesperson to consider all potential outcomes when representing a seller. If a salesperson discovers a significant, previously undisclosed structural issue with the property during a showing that could impact its marketability and value, what is the most ethically and legally sound course of action to uphold their fiduciary duties? Option A. Advise the seller to not mention the structural issue to the buyer, hoping it will not be discovered during the transaction. Option B. Downplay the significance of the structural issue to the buyer, suggesting it is a minor cosmetic problem. Option C. Recommend that the buyer conduct their own independent inspection without disclosing the specific nature of the structural concern. Option D. Immediately inform the potential buyer about the structural issue and advise the seller to obtain a professional assessment and repair estimate. The correct answer is D. Immediately inform the potential buyer about the structural issue and advise the seller to obtain a professional assessment and repair estimate. Explanation. This scenario is professionally challenging because it pits a salesperson's desire to close a deal against their fundamental obligation to act in the client's best interest. The salesperson must navigate potential conflicts of interest and ensure all material information is disclosed, even if it might negatively impact the transaction. Careful judgment is required to uphold fiduciary duties while still serving the client effectively. The correct approach involves proactively disclosing the known structural issue to the potential buyer and advising the seller to obtain a professional assessment and estimate for repairs. This aligns with the fiduciary duties of disclosure, loyalty, and care. Disclosure requires revealing all material facts that could affect the buyer's decision. Loyalty demands prioritizing the seller's interests, which includes ensuring a transparent and legally sound transaction. Care mandates acting with reasonable diligence and competence, which includes identifying and addressing potential problems that could harm the seller or buyer. By recommending a professional assessment and repair estimate, the salesperson is facilitating an informed decision for the buyer and helping the seller address the issue proactively, thereby protecting the seller from future liability and potentially facilitating a smoother sale. An incorrect approach would be to downplay or omit the mention of the structural issue to the buyer, hoping it goes unnoticed or is discovered later. This directly violates the duty of disclosure, as material facts must be revealed. It also breaches the duty of loyalty to the seller by potentially exposing them to significant legal repercussions and financial loss if the issue is discovered post-sale. Another incorrect approach would be to advise the seller to simply ignore the issue and hope the buyer doesn't find out. This fails the duty of care by not acting with reasonable diligence to address a known problem and could lead to severe consequences for the seller. A third incorrect approach would be to suggest to the buyer that they can figure it out later, without providing any concrete steps or information. This is a superficial attempt at disclosure that does not fulfill the duty of care or loyalty, as it leaves the buyer uninformed and the seller exposed. Professionals should employ a decision-making framework that prioritizes ethical obligations and legal requirements. When faced with a situation where a known issue could impact a transaction, the salesperson must first identify which fiduciary duties are implicated. Then, they should consider the most transparent and legally sound course of action that protects all parties while fulfilling their obligations to their client. This often involves open communication, recommending professional advice, and ensuring all material information is documented. Question 20. Governance review demonstrates that a real estate salesperson is advising a prospective buyer on a property where the seller has accepted an offer. The salesperson needs to explain the seller's remaining rights concerning the property until the closing date. Which of the following best describes the seller's retained rights within the bundle of rights framework? Option A. The seller retains the right to possess the property, control its use, and dispose of it by selling it to the buyer, all subject to the terms of the executed purchase agreement. Option B. The buyer gains immediate possession and full control of the property upon signing the purchase agreement, superseding any seller rights. Option C. The seller can no longer make any decisions regarding the property's use or disposition after the offer is accepted, as all rights have transferred to the buyer. Option D. The seller has relinquished all rights to the property, including possession and control, immediately upon acceptance of the offer. The correct answer is A. The seller retains the right to possess the property, control its use, and dispose of it by selling it to the buyer, all subject to the terms of the executed purchase agreement. Explanation. This scenario is professionally challenging because it requires a salesperson to navigate the nuanced rights associated with property ownership, specifically the bundle of rights, while adhering to ethical and legal obligations. Misinterpreting or misrepresenting these rights can lead to significant legal disputes and damage to the salesperson's reputation and brokerage. The core challenge lies in accurately communicating the extent of a seller's rights to a potential buyer, ensuring transparency, and preventing future misunderstandings. The correct approach involves a salesperson accurately explaining to a prospective buyer that the seller possesses the right to possess the property, meaning they can occupy it until the sale closes. This aligns with the fundamental right of possession within the bundle of rights. The salesperson must also clarify that the seller retains the right to control the property's use and disposition, selling it, until the transaction is finalized, subject to the terms of the purchase agreement. This demonstrates a professional understanding of property law and ethical disclosure. An incorrect approach would be to tell the buyer that the seller has lost all rights to the property immediately upon signing the purchase agreement. This is a failure to understand and communicate the right of possession, which typically extends until closing. It also misrepresents the seller's ongoing right to control and disposition, which are still active until the sale is complete. Another incorrect approach is to state that the buyer gains immediate possession and control upon signing the agreement, ignoring the seller's retained rights until closing. This misleads the buyer and creates potential conflicts. Finally, asserting that the seller can no longer make any decisions about the property after signing the agreement, even minor ones, is an oversimplification that ignores the seller's retained control and disposition rights until the transfer of title. Professionals should approach such situations by first thoroughly understanding the bundle of rights as it applies to the specific transaction. This includes recognizing that these rights are not absolute, but are subject to contractual agreements and legal limitations. When communicating with clients, professionals must use clear, precise language, avoiding jargon or ambiguity. They should focus on explaining what rights are being transferred and when, and what rights are retained by the seller until closing. If unsure, seeking clarification from a supervising broker or legal counsel is a crucial step in professional decision-making.